Divorce and the immigration process. Will divorce affect your immigration status while your case is still pending with USCIS? In this video, we'll talk about those scenarios. We will explain to you basically how it might play out as far as some scenarios are concerned. Just stick till the end so you can benefit from this video. My name is Bijou Ngwanda. I'm an immigration lawyer based here in DC. I do work with individuals across the country and around the world because we're dealing with complex U.S. immigration laws cases. If you're into my channel, you know what to do. Please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. Again, if you enjoy the content, you go ahead and share, like. Don't forget to comment below. Don't forget to pretty much follow me on all platforms because we are trying to grow our community. You can follow me on Instagram, TikTok, Facebook group, and Facebook page. We have things going on there as well, okay? You can ask your questions there too, comment on any post, stuff like that. But if you need a consultation one-on-one with me, then schedule it by using the link in the description box below. Well, let's get right into it. So basically, we have a couple scenarios, right? Divorce and immigration. Let's talk about the first scenario with conditional green card. Divorce and a conditional green card. You know, when someone has a conditional green card, at some point they have to go and remove conditions by filing the form I-751. So now if somebody is trying to remove condition, then in the middle of removing condition, they get a divorce, the case is still pending with USCIS. What are they going to do? So the first scenario is that they can basically apply I-751 as a waiver, right? By claiming extreme hardship, okay, to themselves or to the U.S. citizen children. If they have U.S. citizen children, then they can additionally use the form I-601. But if they don't, or they don't want to use the form I-601, based on their own facts, right? Everybody's case is different. Then they can just claim, have an argument, a strong argument of extreme hardship and remove condition as a waiver, but they have to prove that the marriage was genuine, good faith marriage. It just ended in divorce. So it's kind of discretionary for the USCIS officer to basically give you that green card on your own term as a waiver because they're just going to go with their own discretion. But you have to have enough evidence to convince them. Really, extreme hardship can be one of them. If you have U.S. citizen children, then it's even better. Then you can claim it by additionally using the form I-601 pretty much to claim extreme hardship, or you can just go ahead with an argument, a strong one, right, without using I-601. It just depends, case by case basis, okay? So if that one is not your scenario, then we go to the second scenario within the first scenario of divorce and a conditional green card, is that the fact that you apply for VAWA. Why? Because you want to claim abuse. But remember, if it's a case of divorce, then you still have to prove that the divorce in question is based on the abuse. It's because of the abuse that you had to divorce this person, this spouse. So, and then you have to be able to show it with evidence, a lot of evidence, okay? But remember, we still go back to the fact that you still have to prove that marriage is a good faith marriage. The marriage was genuine. It was a valid marriage. It's just that it ended in divorce, either because it just didn't work out. That's when you prove extreme hardship, or it was just so abusive, you file for VAWA. But let's say that you miss that VAWA, because remember with divorce, you have to file within 2 years of the divorce. Let's say you miss that divorce time frame, deadline to file VAWA under divorce. What can you do? Well, if you suffer domestic violence, for example, assault, aggravated assault in the marriage, then you can basically apply for a U visa. But U visa has its own requirements, right? We've talked about it a lot on this channel, but one of them is that you have to be able to collaborate with the police, the investigation team, and you have to be able to prove extreme emotional distress. So that you really went through emotional distress, you have to be able to prove that. How do you prove it? Well, maybe you went to the doctors. Doctors have a lot of reports to provide to USCIS and stuff like that. Those are just 3 scenarios within the divorce and a conditional green card. So now we are talking about the second scenario, right? The second scenario is basically a divorce during the application process. I-130 is pending, green card is pending, then you just get a divorce. My friend, at that point, really, you're out of luck. Most cases, you're out of luck. I-130 pending, green card pending, you just get a divorce in between. If you cannot prove VAWA, that the marriage was a good faith marriage, and it's just ended in divorce because of the abuse, then you're out of luck. Or you can go with U visa, a separate application, but still have to meet the requirement of U visa if you were subject to domestic violence, such as aggravated assault, battery, stuff like that. So, and you really, or rape or something like that, but you have to have enough evidence, collaborate with the police, investigation, and show that you suffer emotional distress, extreme, right? So that's when you want to claim U visa on a separate application. So that's the second scenario. And then the third scenario is naturalization and divorce. Remember that when somebody wants to naturalize, basically to apply for U.S. citizenship under marriage, the time frame or the deadline, let's put it that way, is that 3 years, right? You've been in marriage or holding that green card based on marriage 3 years, for 3 years period of time, or let's say 2 years and 9 months, because you can apply 90 days prior to the 3 years, all right? So, and then you get a divorce, my friend, then you have to go with the 5 years, okay? Because the condition for applying under marriage, the citizenship under marriage, the green card based type of marriage, it's that you have to still be married by the time you're applying for U.S. citizenship, or by the time they're doing the interview, you have to still be married, because you have to prove that the marriage is still valid. So that's it for this video. Again, if you need a consultation, you don't need to call me, just click the link in the description box. Schedule your own consultation on your own time. Really, just do it, but you can call if you want. As a matter of fact, if you call me, just know that I am going to send you the link for consultation. You're not going to get anything out of me, okay? The only time I do free stuff is when I do live sessions, or you can post it on our private Facebook group. But if you need a one-on-one, really, you just have to pay for consultation fees. Schedule it by using the link in the description box. Until next time, bye-bye.